Good morning to everyone and welcome to this webinar on AI governance in the G20. My name is Luca Belli. I am professor at FGV Law School and coordinator of the Center for Technology and Society at FGV. And I will moderate this webinar together with my colleague, Professor Philippe Medon, who is also researcher at CTS-FGV. We have decided to start this very relevant series of webinars dedicated to digital policies in the G20, precisely to explore what are the emerging trends and needs and policy proposals that we can identify in G20 and how they could impact the G20 agenda under the Brazilian presidency. We have the great honor to have here with us today a great set of panelists. We will have Ms. Tatiana Evas from the European Commission, Professor Aifang Ma from the Peking University, and also one of our incoming Cyber BRICS fellows, Dr. Joshua Meltzer from the Brookings Institutions, Professor Sizwe Snail from Nelson Mandela University, also a good friend of the CTS-FGV, visiting professor, and also Cyber BRICS scholars. And last but of course not least, Ms. Zai Vipra, that is also one of our incoming Cyber BRICS research fellow. Unfortunately, Ms. Stella Ragna from the Brazilian Ministry of Justice had a last-minute impediment, so she will try to join us towards the end of the webinar and not as a first speaker. Before we start this webinar, two important things. First, let me also share our usual disclaimer that we need to share at every webinar. So let me just clarify that all the participants here are willfully and willingly participating to this webinar. Their opinions are personal opinions, of course, and do not represent any FGV official policy, and they have, of course, agreed to participate to this webinar and being recorded. So I just wanted to ask the participants to signify their agreement with this statement, either by saying yes or by just raising up their thumbs in this way so that we can proceed. Excellent, perfect. So now that we have expressed consent from everyone, let me just start with a little bit of setting the scene and context to understand why this theme, we have decided to start with this theme, AI governance, and why it is particularly relevant for this specific G20. The Brazilian presidency, coming right after the Indian one and right before the South African one, is a key moment to make sure that the Global South voices are conveyed into the top level of international policymaking and have an impact. And this is also the spirit that we have decided to embrace while organizing this series of webinars, to make sure that leading Global South voices are represented, ideally all Global South voices, but as we are here in the G20 context, we want to make sure that leading key actors from the Global South have enough space to discuss and exchange with leading developed countries and to contribute to the development of joint proposals, right? So the idea of today is precisely to facilitate this exchange. Before we start, there is an important point I want to stress, as we have decided to discuss AI governance, not AI regulation, precisely because we want to make sure that the most recent initiatives based on the creation of AI risk-based framework are not the only topic we discuss. Risk-based regulation for AI is essential, is key, but we feel that that is not the only element that must be discussed into this context. Let me just share very quickly a couple of slides about what I call AI sovereignty which is something we have been working a lot at CTS, and I think is emerging as a very important discussion, even if the AI sovereignty label is not universally accepted or shared, but that is something that in the global south is driving a lot of discussions. So what I want to propose also as a topic for debate in the question and answer toward the end of the workshop, of this webinar, is this concept of AI sovereignty, and the fact that it is an expression of what most of the global south may be thinking about digital sovereignty transitioning to AI governance. So the fact that it is not only, of course, we may consider digital sovereignty and sovereignty in general with multiple acceptions. We can see it as control, authoritarian control. We can see it as protectionism. But there is an important dimension that I would like to stress to start this debate, which is self-determination. So not sovereignty or AI sovereignty or digital sovereignty, meaning controlling through technology, but sovereignty meaning understanding how AI systems work, being able to develop them and exercise self-determination, both of individuals and of nations, right? This is something that I'm mentioning because last year I had the chance of introducing this debate in the G20 with this paper on good digital sovereignty, precisely to stressing that we have not only bad notions of digital sovereignty linked with authoritarian control and protectionism, but also good ones linked to strategic autonomy and self-determination, right? So there is this paper I shared last year that provides very good insight on what I like to define these key AI sovereignty enablers. And this is precisely the point I want to stress to start this discussion. As you see here, these 8 enablers that compose this AI sovereignty stack include also risk-based regulation, which has been hitting the headlines, especially with the great work that the European Union has been doing with the AI Act, but also because many people discuss a lot of risks that AI can bring, a lot of benefits, but not how to see the full picture. So I want to introduce this idea of seeing the entire AI sovereignty stack to understand that risk-based regulation is only one of the key elements we need to consider if you want to be AI sovereignty. We have to have research, development, and regulation also in other elements. Data, including personal data, algorithms, computational capacity, and this is key. I mean, over the past months, we have had several discussions on how concentrated is compute and cloud computing that is necessary to develop AI, how extremely concentrated is the semiconductor market for AI nowadays. So these are critical elements that we need also to discuss when discuss AI governance, meaningful connectivity. If you are not connected, you are simply out of AI development, reliable electrical power, which is something key for global south countries and not even considered by the most developed country, digitally literate population, solid cybersecurity, and of course, last but of course not least, risk-based regulation. So having said that, I just give the floor to my colleague, Felipe Medon, who is not only the co-moderator of today, but he also had the pleasure of being one of the members of the Brazilian Senate Commission on the AI regulatory framework. So he can provide us a little bit of food for thought on what is the Brazilian most recent thinking about AI governance. Please, Felipe, the floor is yours.
Thank you so much for your introduction, Luca. Good morning, good afternoon. I'm Felipe Medon. I'm civil law professor at FGV Rio Law and researcher at CTS as well. I'd like to begin by thanking everyone who is watching us for their attention and our very special guests who have been so kind in accepting our invitation to be part of this discussion, as Luca mentioned, of paramount importance. I'll be very brief on my opening remarks. I'll just try to highlight a couple of topics that I consider to be relevant to the AI governance in the G20 from a Brazilian perspective. The first is that we are currently living the era of the emergence of AI legislation around the globe. It seems clear to me that this is the first wave of many yet to come. And Brazil is definitely, as Luca pointed out, Brazil is one of the first movers, since it is expected that our federal Senate should vote the so-called Bill 2338 by April. And it is very unfortunate not to have Stella here with us today, since both of us have been part of the Commission of Justice who have drafted said bill. But nevertheless, we must proceed with caution in order to avoid the new legislation is approved without the maturity desired. So it is also great to have Tatiana with us here to tell us more about the lessons which we could learn from the approval of the AI Act. Secondly, as far as information integrity is concerned, fighting fake content is one of the priority agendas of the Digital Economy Working Group in the G20. The UN recently published a report on the concept of information integrity, calling on states to create regulatory responses to protect not only said integrity, but also disinformation. So this urge for international cooperation is something that we should consider. We could name, for instance, the Global Declaration on Online Information Integrity, the Forum for Information and Democracy, and the UN Secretary General's Code of Conduct for Information Integrity on Digital Platforms. And I would also like to draw our attention to the fact that we are living a global election year. The use of AI technologies, especially generative AI that produce the so-called deepfake content, is something to be taken into our very special consideration, given the perils of disinformation, as we have seen in recent electoral processes, such as in Slovakia and Argentina. The risks to democracy are unquestionable. And in this sense, one of the most critical points seems to be the discussion regarding social media content moderation and the role of platforms. How can we use AI technologies to help fighting the dangers created by AI? Brazil is signing significant partnership and agreements in this field. For instance, our Superior Electoral Court has been acting in cooperation with certain platforms to prevent and to reduce the circulation of fake content. I also had the honor to be part of the public hearing that is discussing one of the new legislation on this sector. So it is really important to stress this topic. It is also great to have Joshua here with us, since the Brookings Institution has been producing a truly relevant work related to the use of AI in elections. And finally, before giving the floor to our guests, I'd just like to comment on another topic, which is the military use of AI, which is something that unfortunately is not receiving enough attention in the G20 discussions. The risks are enormous, especially as far as lethal autonomous weapon systems, the so-called LAWs, are concerned. Brazil is playing a very relevant role in these discussions internationally, and that should also be taken into consideration in the G20, notably when it comes to domestic violence and the risks of bias and discrimination. In the G20, we have been focusing on smart cities, but the use of AI in public safety must also be one of the key topics of analysis. So these were my opening remarks, and I'd like to move on to introduce our first speaker. I'd like to introduce Tatiana Avas, who is a legal policy officer at the European Commission DG Connect International Affairs. Tatiana, thank you so much for accepting our invitation. The floor is yours.
Thank you very much for Felipe and Luca for a nice introduction and setting the scene. I think what you outline is very important. I mean, the global discussions and the general move towards, like discussing AI in more global perspective. Of course, now there is a lot of interest in general purpose AI models and on the like risk-based approach, but I fully agree with you that we need to look more holistically at the AI issue, because AI is just a tool and technology and maybe like almost a result, which takes us to a certain thing, but it's not the aim in itself. So we, of course, in the European Union, we always saw the AI Act as one part of the package. So it's not the aim in itself. We just don't propose regulation for purpose of regulation, but it have a certain mean. And maybe you ask, maybe to Lucas and Philippa's comments are actually interlinked about the lessons learned and this broader concept and concept of AI sovereignty. Of course, they're interconnected, what are the requirements? And in the European Union context, we started to discuss the issue of artificial intelligence already from 2015. So just to give you many people just focus on the Act 2021, proposal, but in European Parliament, we had a working group, expert group, that started actually being called as the Civil Law Rules on Robotics. We started to discuss different rules related to robotics, but already then in 2015, so long before ChatGPT conquered the world, it was clear that we need to actually integrate AI. And the final report, which was adopted in European Parliament in 2017, already spoke about AI. And at that time, we were in the European Union, let's say, in very unfavored situation, because in globally it was said, what are you doing? It's something which you should not mingle in, we need innovation, we need just, encouragement. And in this 2017 resolution, which was much before AI Act, we already set certain elements related to ethics of AI and actually putting emphasis already on the providers and developers of AI systems, to take certain responsibility, which I think is very important. And of course, with AI Act in 2021, when the European Commission make a proposal, we kind of solidified that. But I also want to bring attention that in 2021, European Commission adopted 3 documents. One is AI Act, second is the coordinated plan on AI, and third is a communication. And we always see AI as, let's say, standing on 2 legs. One is trust, which is regulation, AI Act, and excellence. Excellence for us means research, innovation, development, investment, computational capacity, and all of this. So coordinated plan on AI, which also was published together with AI Act, outlined actually our vision, in how we integrate. So, and we were always saying that you need 2 legs to run, so you need both trust and excellence, to perform. So for us, that's always the approach. And sometimes in global discussions, I see that we focus very much that EU proposed AI Act and we are regulating, but not speaking so much about the second leg, which for us is equally important. We don't say which leg is better, right or left, we are both important, and that's what we want to stress. And most recently, actually at end of January, European Commission also adopted a new communication, which pretty much re-emphasizes the importance of the other measures than just regulation. It's called AI innovation communication. So we exactly speak about the computation, high capacity performance computing access, especially for small and medium enterprises. We speak about like testing, more providing for testing experimentation facilities, more giving the companies for tools to experiment. So it's definitely on EU agenda, and I kind of really urged also to look at these documents and not all the time speak about AI Act. It's not to downplay AI Act. AI Act is important, but exactly as Luca said, it's just one component of our package. And maybe here, then maybe some lessons learned. I think whatever we propose in terms of regulation, which is also very important. And I'm very much proponent of the product safety approach, so not only rights-based approach, where we empower individuals to bring their claims against, for violation of the rights by AI systems, but also product safety legislation, but actually putting the provider a certain degree of responsibility and risk management obligations already while designing. So I'm very strong for this. But I also believe that with one piece of legislation, we cannot solve all the problems. So also too in trust and say, okay, now we adopt regulation and all the worries are solved. I think it's also wishful thinking, which cannot be resolved. For that reason, of course, in European Union context, we have general data protection, so GDPR, you know, for privacy and data. We have consumer protection. We have anti-discrimination law. So again, AI, of course, AI technologies bring a new dimension, but other pieces of legislation will remain existent. And maybe we need to fine tune, for example, on liability, on consumer protection, but we are there. And I think it's also a bit of kind of, sometimes I feel in public discourse, but also at the international area, that we try to solve with one instrument or one document, you know, with all the worries, which I think is not correct, you know. So it's exactly speaks to your also understanding of holistic approach, which I think we also need to take at the level of international discussions. And therefore, I really appreciate your framing, and also framing in G20 as a more complex problem and issue, you know, both with opportunities and risks and enablers and capacity building, you know, so how all these elements are built, but also really not just focusing on these specific pieces of legislation, but also extending it to other, you know, like pieces of legislation which enable this. So I guess that's one of the, for me, lessons learned. And then maybe before I conclude, also to give possibilities for other speakers to intervene, I really think the approach which we, if now we speak about AI Act, we approach, like I already mentioned, to product safety approach, you know, plus risk-based approach is really very solid foundation. And I explain why, because first of all, it puts the burden, bigger burden and responsibility on the provider, on the designer of AI system to show actually compliance with requirements, which actually makes it for individuals easier, you know, than if they have already technical documentation, if they have already conformity assessment. So it actually, for us, it's very important to build this trust with the product AI system before it's put on the market. So before, you know, not after, you know, it's already checked by certain experts. It's also because individuals, you know, it's not so easy, you know, it's not like with some piece, easier product, you know, which you can taste and say, is it good or bad? You know, you really have to trust that experts can check before the product is in. So that's why this product safety legislation approach is very important for us, meaning the product is checked before it's put on the market. So AI system is checked by professionals. And here I wanted to highlight, of course, this risk-based approach, but maybe experts know, so I don't need to explain. What I want to say, what was very important to us, that although we built on product safety legislation, which usually only covers risks to health and safety, in EU, we added also fundamental rights, because we really believe that AI can lead to a lot of inequality, misinformation, disinformation. So what we're asking now is this product safety enhanced approach, you know, so it's health, safety, but also fundamental rights. So providers of AI system, before putting product on the market, have to show us and like have risk management system which would address risk to health, safety, and fundamental rights. So product safety legislation, but with fundamental rights, not putting fundamental rights aside. Risk-based approach, it's true that we need to leave the space for experimentation and maybe seeing the regulation, exactly as Luca was saying, in broader perspective, contextualizing also with other measures. And I think I conclude here.
Fantastic. Thank you very much, Tatiana, for the very good overview. And I really love the concept of these two fundamental pillars of AI governance. On the one hand, trust, so regulation and risk-based approach, but also on the other hand, also excellence. And so all the research and development that are needed to be able to understand and develop AI. And these are both extremely difficult elements to build. They take decades to build them, to develop an understanding. You really rightly pointed out that the EU is discussing this since 10 years, indeed, since 2015. And it's very interesting to see also another approach that is not, or maybe is becoming risk-based, because we have seen that in China recently there have been a lot of proposals on both. There has been regulation on generative AI and the proposal of a general law on AI, but also China is known to have had very intense industrial policy that has driven the development, the excellence in the AI over the past decade. So I would like to give the floor to Aifang Ma from Peking University, and also one of our incoming Cyber BRICS project fellows, to illustrate a little bit what has been the Chinese approach to AI governance, and with a particular focus, if you can, on industrial policy, which will be one of the main topics of discussion and research of the Cyber BRICS project this year. Please, Aifang, thank you very much for being with us. The floor is yours.
Thank you very much, Luca. So it's really my pleasure to participate in this webinar, and also many thanks to Tatiana and Felipe Meudon for your presentation. So now I'm going to share my screen for my presentation. All right. Do you see my screen, right? Just one moment. Do you see my screen? Yeah? No?
You have now lost your screen. I think you can reshare it again. Now we can see it.
Yeah, okay. It's fine, right? Okay. Thank you. Okay, perfect. So today I'm going to present the two-level regulation of AI in China, basically at the central and the local level, before talking about the AI regulation of China against the background of the geopolitical competition. So basically, I think it's important to have a look at this table. So in China, the regulation of AI is basically happening at two levels. So the dynamics of the regulation at the two levels are very different. At the central level, the regulation is led by a political regulator, so the Cyberspace Administration of China. So this regulation body is basically a content regulator for the online speeches, but since its institutional ranking is very high in China, it reports directly to the party leadership. So its competencies have been enlarging in these years to include the regulation of data protection, the regulation of blockchain, the regulation of generative artificial intelligence as well. So the regulation at the central level also is simultaneously facilitative and restrictive. Facilitative in the sense that the regulation is intended to drive up the technological innovation and also the economic potential of the AI. But it is also restrictive because the Chinese government is basically competing with the EU and the USA, so to set up the regulation rules to stave off the risks related to the artificial intelligence. And then for the resources, so the central level regulators have the capacity to make the binding rules. They also have the financial, administrative, and the organizational capacity. At the local level, the institutional layout is very different because the regulator there is an economic regulator. So it is the local outpost of the Ministry of Industry and Information Technology. So their main concern is to drive up the technological innovation, so not to regulate the risks. So the regulation of risks is basically done by the central regulator. And then also in China, the local regulators also have the capacity to make binding rules. So through the municipal parliament, the municipalities and the provinces can make regulations, they can make laws with binding effect. And then there are also, so at the central level, as I said, so there is the shift of regulation priority before and after 2019. Before 2019, basically the Chinese government is like the local regulators. They basically focus on unleashing the economic potential of the artificial intelligence. After 2019, there is a shift of regulation priority. So today, basically the central level regulators simultaneously emphasize the facilitative and the restrictive function of the AI regulation. And then, so this is the situation before 2019. So I wanted to emphasize the development plan of the next generation of AI. So as I argued in one book I published in 2018, so this is the landmark for kicking off the AI development in China. So in this document basically says that China has the ambition to become a global leader in AI by 2030. And this document also lays down 6 priority tasks. So basically in these 6 missions, there is, well, basically all these 6 missions are related to reinforcing the building of the infrastructure for AI development, and also to enlarge the industrial applications of AI. There is a few mentioning for data security and privacy protection related to AI, but the wording for the privacy protection is very fluid, is very ambiguous. There is no explanation about which regulator is going to enforce the privacy protection, and there is no explanation about how the privacy protection is going to be organized. So basically before 2019, the privacy protection is not a priority for the Chinese government. But after 2019, there is a change in the regulation priority, starting by the release of the 8 governance principles of AI in 2019. And also in the same year, the party leadership established the National Science and Technology Ethics Commission, which is in charge of regulating the ethical related problems of AI. So this is an institutional progress for the AI regulation. And also after 2019, the regulation has become more detailed in the sense that the regulation is becoming a sector specific. So specific rules have been released related to the news information, the application of AI in the justice, and also the application of AI in the military for military purposes. So these are the 3 very clear, very important regulation after 2019. There is the regulation of algorithmic recommendation, the deep generative services, and also the generative artificial intelligence, which is adopted very recently in May 2023. So in this document, so in the generative artificial intelligence, basically, the Chinese government is imitating the European approach to regulating AI, meaning that the Chinese government is also adopting a risk-based regulation. But at the same time, it also says that we are going to be tolerant, to be prudent, so not to sacrifice the technological innovation at the cost of the regulation. And then at the local level, so the equation at the local level are very simple because the local level tends to innovate in the technological terms. So in China, we have a phrase, local regulators try, central regulators codify. So this word. So this sentence means that the innovative industrial policies are basically innovated, worked out by local governments before being legislated and codified at the central level. I give you two examples. The first example is found in Shenzhen, which is located to the south of China. So one innovative policy adopted in Shenzhen is that, so if the researchers or their teams have succeeded in overcoming the major technological bottlenecks in the AI development, so the researchers can hold proprietary rights of their findings and they can use them for a long period of time. So this is intended to encourage their enthusiasm in the research. And also, I wanted to give you another example about the driverless cars, so the autonomous driving in Wuhan. So there is an application which is called the Reddish Run, which is rolled out by Baidu in 2021. So this is the driverless taxi rented from the app Reddish Run in Wuhan. So Wuhan is traditionally in a very important base for the automobile industry in China. So combined this advantage, the Wuhan government has cooperated with the Baidu company so to try out the driverless car in the city. So in 2023, the Wuhan has become the largest city in China with the strongest autonomous driving in the country. So this is Beijing. So this is a picture, a photo I took in Beijing. In Beijing, basically, this is another important city for the AI development. So here, this is in a supermarket. So you see a robot which is cleaning the floor in the supermarket, which is near my house. And also, this is the smile to pay. So I took this photo in a university fitness center. So you see this young student. He is basically buying snacks, and then he's trying to pay by scanning his face. So this is also very developed in Beijing and also in other cities of China. So why there is this shift of the regulation priority, in particularly at the central level of China? So basically, today, I think that for the Chinese government, so to regulate the AI has become as important as to develop a sophisticated AI system. I wanted to emphasize a difference between China and the European Union and also the United States. So China is basically an authoritarian state. So there is a paradox for China. So the more China has sophisticated AI, the more it attracts suspicion. So basically, to regulate AI is for the Chinese government an important way to dissipate the suspicions around the AI development and the AI investment. And also the second one is the institutional pressure that the EU has been wielding on China. We see that the EU is basically a regulation example in the world. Therefore, so the regulation method of the EU has produced quite a lot for pressure for China. So now some takeaways before I conclude is that I think that for the G20 with the Brazilian presidency is that we should try to unleash the innovative potential of the local governments, just like in China. So and then to leave a greater space for the industrial application of AI, because the firms cannot know what are the risks if they do not deploy the AI in their services. So I think that it's a good suggestion to leave a greater, a more liberal space for the firms to try the AI in the first place before finding out the loopholes. That's my presentation. Thank you very much.
Thank you so much, Ifan, for your fantastic presentation. Thanks for sharing with us your remarks and to allow us to have a better understanding of the Chinese framework on AI governance. You showed us how the AI regulation is happening in a two-level basis and its advantages. You also mentioned the international scenario, highlighting the undergoing efforts from China to become a global leader in AI in this geopolitical competition. China is definitely a first mover in regulation, notably when it comes to subjects like disinformation and generative AI. The driverless car subject really speaks to my heart, and it also links to Tatiana's remarks on product safety legislation. My first book was about cyber liability. It was my master's thesis, and this is a core issue in the complex regulatory puzzle. In Brazil, just to give a comparison, this subject of cyber liability is probably going to be addressed by our AI regulation, unlike the European Union, who is leaving that to a separate directive. And that is something for us to think about. Should we address this topic in a product safety legislation, in a more specific, detail-oriented, or should it be a chapter of an AI bill? And more than that, do we need legislation on cyber liability, which is something that we must try to understand, since Brazil has a different, and I would say even a more broader, more comprehensive legislation on cyber liability than the European Union, for instance. That's something for us to keep in mind, and this discussion is truly helpful. That being said, I'd like to introduce our next speaker, Joshua Meltzer, who is a senior fellow in the Global Economy and Development Program at the Brookings Institution, and he's a co-leader at the Forum on Cooperation in Artificial Intelligence, where we've met. Thank you so much for accepting our invitation. The floor is yours.
Great, pleasure to be here, and I'm actually just searching now. I wanted to say, pleasure to be here, and Luke, I really enjoyed your kind of introduction because I think as we think about expanding opportunity and access of AI systems globally, I think your point that the regulatory piece is a small part when you think about it holistically is very well taken. We're certainly doing a lot of new work in that space, and not only is it a small part, but it's potentially less significant when you think about the range of kind of barriers that are there to developing AI. So with that, what I thought I'd do I'm going to do this fairly briefly is I'm going to run through what's been happening in the US, but I do want to focus on I think I've been asked to focus on the executive order on AI. That's not the only thing going on in the US, but it's certainly probably one of the most significant developments in the last 6 months, and it's going to inform a lot of what happens next, and I'll provide a little bit of context to that. But the EO, the executive order was issued. I'm sure these are quite familiar to everyone online, so I'll provide a little bit of detail, but not tons. It was issued in October, end of October last year, and it essentially sets forth quite a wide range of federal regulatory principles and priorities. It's going to that's direct a whole range of federal agencies to then develop standards and guidelines, and the Act as well, I think, significantly invokes the Defense Production Act, and this has historically been the key source of presidential authority when it comes to commandeering or regulating the private sector to support national defense. And so I'll talk a little bit about what the EO talks about in terms of the Defense Production Act and the national defense angle, because that's certainly quite important. But the EO came on the back of these so-called voluntary commitments that were made by about a dozen leading technology companies in, I think, June last year, at the White House with a meeting with the Secretary of Commerce, Gina Raimondo, which focused on the so-called sort of frontier AI models. And I do think it's worth stating at the beginning that increasingly, certainly what you see in the US, we saw this as well in the development last year with the AI Act in Europe, the way that, you know, generative AI, large language models being an example of that, but these foundational models are being a different type of regulatory sort of challenge, in a sense, than other forms of more kind of enterprise orientated AI ML. And from a development kind of, you know, expanding to the global South perspective, I keep thinking that, you know, we don't want to get sidetracked by foundational AI models. A lot of the productivity kind of enhancing opportunities and benefits that are companies already using, you know, globally, and have been actually around for quite a number of years, are not foundational AI models, yet they're the ones that are sort of being used in a B2B sense. They're not raising the types of sort of high risks that the EU gets focused on. You know, they're very much about kind of enterprise management, you know, supply chain management, warehouse management, you know, improving the operations and efficiencies of professional workers and so forth. And you know, that they have a particular, you know, you want to make sure that risk is appropriately regulated, but it's a different type of risk in many instances, not all, but many instances, than the risks of foundational AI models. And that's why you see in the US this bifurcated approach emerging, I think, between the way that the government is thinking about these very powerful sort of leading edge foundational AI models and the rest of AI. So back to the EOs. So I guess a couple of things just to sort of set the scene is that, you know, the EOs, because it's coming out of the federal government, its focus essentially, its authority is essentially, you know, a combination of, you know, directions to the federal agencies, which, you know, the EO is able to approach directly, and then some power over what the private sector is then required to do through the Defence Production Act. And in terms of the federal agencies, the impact of the EO is essentially going to arise as this range of federal agencies starts developing technical standards and guidelines really over the next sort of 6, 12, 18 months that will both influence how the agencies themselves use AI, but it will also, you know, seep indirectly into how the private sector uses AI, because it will also be used in procurement, in government's purchasing power, which is obviously very significant. And so through that mechanism, that will also be an important kind of way that it will start to guide the private sector market. And, you know, this is going to be across, if you look at the AI, it's across financial services, healthcare, biotech, energy, transportation, telecommunications, IP, competition. So it's very, very broad in terms of its scope. And I think also significantly is that the EO is also mandating that all federal agencies have chief AI officers. So we're going to have essentially a chief AI officer, you know, throughout the executive branch in all these federal agencies. There's a new White House AI Council. And so there's a range of sort of institutional mechanisms that have been developed that are being put into place. So I think that's important, because I think there's a design question for governments in terms of how they think about regulating AI, and because it's such a cross-cutting technology that, you know, I think the view that's developed in the US is that you need to have the expertise to be widely dispersed. So there is some sort of centralization in the White House, which is typically the case because it's where sort of the interagency process happens, but it's also recognized that each agency needs its own AI expertise. And the EO is actually quite focused on not only having these chief AI officers, but actually putting in place the programs to make sure that the federal agencies actually have the training and the resources that they each need to ensure that they're essentially kind of regulating AI appropriately in their own specific regulatory areas. So the longest section of the EO is focused on the risk of AI in the context of national security, and this is where the Defence Production Act comes into play, because that's sort of, as I said, that gives the president authority to sort of essentially claim some ability to mandate particular actions by the private sector in order to achieve national security goals. And this is where there's very much a focus on what it calls foundational models, and in particular dual-use foundational models, right? So this is the hook that gets you to national security. It's the foundational models that both have sort of commercial economic applications as well as national security. And there's a view that a lot of these AI foundational models are dual use. And so what it's essentially requiring of the private sector is reporting requirements on potential dual use models, and particularly high performance models that could be modified and pose serious national security risks, requirements to report to the federal government how they train and test these models, including the results of red teaming testing. Also, I think significantly is to provide the federal government with specific information about any large-scale computing cluster, including the acquisition of any large-scale computing cluster, where it exists, the power and location of these clusters as well. And I think this gets to, I believe it might have been you who mentioned the sort of concentration in cloud computing, but I think it really underscores the central role that compute is going to play, particular for these high-level foundational models, because in many respects, the compute that's going to be required, that's required today, and if you look at sort of the forecasts for the next generation of LLMs and so forth, the compute has been and will continue to grow exponentially. That there's only going to be so many companies and essentially places where you can train these models. And so it's actually quite a choke point. And from a regulatory perspective, it makes a lot of sense to actually focus on these choke points to give you a window into who's training the models, where are they being done, and so on and so forth. So I think that, there's both a development aspect. I think that's probably, Philippe, maybe where you were getting at it, because obviously you need access to the compute and a lot of it's on the cloud. But for these foundational AI models, it's also very much an important regulatory focus. And so there's a lot in the EO about kind of making sure that the government actually understands where these foundational models are and who's providing the compute to train them. And a lot of that will be essentially large US cloud computing services. But it will, I think, in effect mean that using, there's not really a lot of alternative large cloud computing providers outside of the United States providers, but I think it will mean that now that there's a national security lens on this, there will be a lot of focus on companies that may decide to use cloud computing providers that are coming from, countries that are sort of considered adversaries to the US. Another area where the EO is important is that it's very focused, as I said, on developing new standards. And so there's quite a bit in there on directing the National Institute for Standards and Technology, NIST, to develop guidelines, both for the red teaming that is going to have to take place for these foundational AI models, but also more broadly for a whole range of AI applications and uses, including in critical infrastructure. NIST has actually been already central to developing AI standards in the US. They developed the AI risk management framework about 1.5 years ago, and so there'll be a lot more going on there. There's quite a bit in the AI on privacy. So there's also a lot on essentially responsible and trustworthy AI. Everyone knows that the US doesn't have a federal privacy law, but there are privacy requirements under the Federal Trade Commission, under specific privacy legislation, and then there's a lot of privacy requirements at the state level, but essentially directs the federal agencies to look at how the storage, processing of data and using it for AI affects privacy, and to use their powers to ensure protection of privacy. And then you can kind of go, there's a lot that kind of goes through the AI on issues around ensuring consumer protection and a balance. This is, again, a risk-based approach, which everyone has been talking about today. Similarly, it gets reflected consistently in the AI. There's a direction to the US Patent and Trademark Office to start developing guidelines and thinking through the issues about inventorship and use of AI, the intersection of AI and IP, which is a really big issue in the US. There's some directions in there around ensuring that there's fair competition when it comes to AI as well. And so I think that's kind of the core elements in there that are most relevant for today. I'd just say quickly with respect to the G20, I don't hold on. I think the G20 has obviously spoken quite a bit about AI. I think that the area where the G20 could, make progress, in fact, would be on foundational AI models. China's obviously, developing and has got the capacity for foundational AI models. There's some foundational AI model capacity in Europe as well. It's an area where the risks are most acute, and you would think that there's an opportunity to start developing some common principled approach to managing risks from foundational AI models. And the code of conduct that the G7 adopted, I think, is really the building block for that. So I think taking that code of conduct into the G20 would be a huge step forward. I'll stop there. Thanks.
Thank you very much, Joshua, for the excellent points raised and actually for highlighting the complexity. I think one of the important points that observers have noticed analyzing the executive order of the Biden administration is precisely that it tries to connect all the dots, and there are a lot of dots to be connected, and each of them is very complex in its own. I very much also like the point on compute that I was raising in the very beginning, and the fact that this is actually an important choke point on which regulators should focus, and on which there are also more element of complexity, thinking that each of those very large computing infrastructure that are necessary for AI also have enormous environmental impact. So it's a very tricky element to consider, even from competition perspective. You have more competition, then you also expand the environmental impact of it. So it's not necessarily the best choice. So it's a very difficult trade-off for every single regulatory decision that has to be taken. And the interesting thing of the executive order, it really tries to take a systemic approach to all the risks and all the advantages that exist. Well, now let's try to focus on a different continent and a different country, South Africa and the African Union. Professor Sizwe Nile, that is one of our visiting professor at CTS-FGV, good friend. We have been working a lot on data governance over the past years, and he has a very interesting view on this kind of developments, not only as a scholar, but also as a former board member of the Information Regulator of South Africa. So, Sizwe, thank you very much for being again with us. Please, the floor is yours.
Thank you, Prof. Can you see my screen? Thank you, Prof. Thank you very much to the G20 webinar on allowing me to be here today. I will be presenting, let's just say, a summary of what is happening in South Africa as well as the African continent. So the overview, obviously, will talk about our conventional definition of AI. Then we'll specifically go into South Africa from the constitutional point of view. One or two interesting cases relating to AI, and then the developments in Africa. Those developments have really been a lot, and I'm happy to share those developments with my colleagues here. Right. I speak to the converted. There's no need for me to tell you about John McCarthy and what AI is and the various definitions of AI. I think I'll be doing injustice to myself. But there are definitions of AI which are mutually exclusive, and it's quite interesting from a legal point of view to understand the definitions of AI so as to understand the context, legal context, and the socioeconomic context of AI in Africa. Now, naturally, I'm from South Africa. I will obviously choose my country first. And South Africa being a constitutional country, we, just like the European Union, will always look at the Constitution. Constitution, including the Bill of Rights, and how AI affects people. The aspects of transparency, accountability, privacy, not promoting bias, AI bias, and discrimination, as well as freedom of expression, freedom of the sciences, freedom of invention, freedom of trade. These are the basic human rights that our South African AI law is buttressed in. Now, South Africa, unfortunately, has not been a leader in AI. However, we have not, I guess, we have not slept, but as late as 2019, our government started looking at a presidential commission dealing with the fourth industrial revolution. And within that, the catchword AI, the research word AI, the legal conundrum AI also came out quite clear. Now, South Africa as it is, we don't have any legislation dealing with AI. We don't even have a bill. But interestingly enough, we do have some pieces of legislation, such as the BOPIA, our Copyright Act, our Electronic Communications Transactions Act. Another colleague told me earlier on some amendments to the Medical Health Act also includes references to software programs and AI as it's referred. Don't want to sit too long on South Africa because I really want to talk about Africa. But we've had 2 groundbreaking cases, in fact, 4. The other 2 are not so groundbreaking. I've only stuck to the ones that are. Parker versus Forsyth. You know, this is the case where a legal colleague like you and I, was caught napping because he took shortcuts, used AI. Our court said, look, you need to respect client's money. A client comes to you and gives you money. You promise to have applied your legal mind. And if you use AI and it gives you incorrect results, you may end up having a cost order, which is what happened in this particular place. We also have another case, the case of Liu, which I also don't want to stress too much, where a presiding officer, so it's not a lawyer, but a judge, took to AI, better put Google, to go and look at the existence of an extradition order. The court had a lot to say about that, and a slap on the wrist of that judicial. What is more interesting for me for T20, because T20 obviously is a regional initiative. We're not just looking at countries, we look at regions, is how Africa deals with AI. Now, we've had, from the infancy of the Malabo Convention, we've had a very distinct section, 14, that talks about the regulation of automated decision-making. It's quite similar to the section in the BOPIA. Basically says, look, you have my data, don't just do as you please with my data. You can't make a decision about me, about my data. And obviously, the application of AI makes that much easier these days. Now, the African Commission on Human Rights, during COVID in particular, had to really look at the effects of privacy and AI and how this affects us as an African people, not just South African people, but African people. There are some resolutions that were taken, in particular, Resolution 473 of 2021, where the African Union specifically spoke about legal, ethical, safe, and secure opportunities for the legal reform of AI technology. And this is big, you know. Robotics also emerging technologies. Finally, Africa as a continent has decided to regulate AI. The resolution goes further. It calls on private business, it calls on governments, it calls on all the stakeholders, national, regional, sub-regional, to make efforts with regards to AI. Now, the African Union Digital Strategy on Information for Africa, very, very clear. And I had the pleasure of reading Ngube et al., a new book on artificial intelligence and the law of Africa, where reference was made to the AUDS, the digital strategy, to say we need African rules, minimum rules, that will deal with the creation or governance. I listened to Prof. earlier. It's not just regulation, but it's also governance of AI, in particular to have AI to be cooperative, transformative, inclusive. AI has the potential to discriminate, as we know. We want homegrown solutions. We don't want to import solutions from other places. We want African solutions. And we want to do so in a digital, mature African space. This was quite refreshing when I read this. And we also have the draft African Union AI strategy. So in 2023, excuse my mistake there, I wrote 2013, the African Union Development Agency and NEPA sat down and said, look, we need to develop a comprehensive strategy for African countries to deal with AI, not just for social economic transformation, not just to create jobs, not just for new industries, but to increase productivity as well as the efficiency of AI. Numerous African countries have created AI strategies, which is once again very refreshing. Fortunately, South Africa is not there, which is worrisome to me. But Rwanda, Egypt, Mauritius, Cape Verde, we saw them in the World Cup. I mean, not the World Cup, sorry, the African Cup recently. Cameroon, Congo, Equatorial Guinea, Eswatini, a small country east of South Africa, Rwanda, Ghana, Madagascar, Sao Tome, Tunisia, up in the north, in the Arab Maghreb, Egypt, and our neighbor Zambia, as well as Zimbabwe. They've all taken up arms to deal with AI and coming up with strategy. So I don't want to overstep the time that is allocated to me. I hope I've given some views and perspectives on AI in Africa. I believe the Q&A will be after everyone has presented. Thank you, Prof. Bailey.
Thank you so much, Sizwe, for your amazing presentation that has allowed us to have a deeper understanding not only of the South African, but from the African perspective on AI. The definition of AI, as you pointed out, is not something easy to talk about. the G20 is a good opportunity for us to try to come up with a good agreement on what we understand as AI, since it affects so much what is being regulated, the scope of regulation itself. It was also very interesting to hear that in South African law, a computer program can be also an author in the terms of your Copyright Act. Also great to hear that the Medical Health Act is being adapted to address AI. You focused a lot on the overlap between AI and privacy. And the digital mature African space is another concept that you've brought that I'd like to highlight. So thank you so much for being with us and bringing this very interesting perspective. Finally, I'd like to introduce Zai Vipra from the AI Now Institute. She's also from the Cyber BRICS project, and I'd like to thank you so much for accepting our invitation, and the floor is yours.
Thank you, Felipe and Luca, for having me here, and it's been so great to listen to everyone. And I'll just speak a bit about India today. And the headline is that it's still undecided as a country, and there's nothing concrete yet in terms of an AI strategy, AI regulation or governance strategy in India. It's also an election year, so it's not necessarily a priority at the moment. But prior to this, we've seen a bunch of reversals in position. The government has at one point said they would want to regulate and then said they don't want to regulate yet. There was some talk of regulating high-risk AI systems, so the Brussels effect that we've talked about, but nothing much has been done. There is a chapter in the Digital India bill, which is still a draft and hasn't been introduced. And that also the introduction of that bill is also up in the air at the moment. So we don't know if it will actually happen. In general, I would say the identity of the government is that they want to be pro-innovation, but they have hit upon digital public infrastructure as a sort of quasi-regulation, especially in concentrated markets. So just to make an intervention that makes the certain markets interoperable. And obviously, concentration is a problem in AI markets. I'm interested to see what kind of DPI solutions come out for this market as well. And I think we can understand all kinds of socio-technical interventions as a general form of DPI. So it doesn't always have to be a platform of platforms or a protocol of some sort, but it does have to be a socio-technical intervention that tackles the privatization of what should ideally be public. There is some talk of democratization of AI and of using regulatory technology, but again, it's all quite up in the air. I know that India is concerned about access to compute as an issue, so as many countries are, but it isn't really able to take a strong stance on this because of its general vacillation between the global south and the global north and the geopolitical balancing that it always tries to do. There is a semiconductor strategy that I think has not been extremely successful. It hasn't borne much fruit. There has been some success in inviting investments in assembly, testing, and packaging, but not in design or fabrication. But that isn't surprising because it's obviously a very, very difficult market to just break into like that. It's extremely concentrated again. Just coming back to the Digital India Act draft for a bit. Like I said, there isn't a public draft out at the moment, but it does seek to revamp the legal landscape for digital governance in India. And it does look at unfair trade practices. So there might be something that is related to platform regulation in favor of third-party actors on platforms that may also apply to AI platforms. It's too early to say. There is concern in the discussions around the bill about global value chains and where India fits in, and also about data governance. There are efforts that are not part of the government, but of other actors, non-governmental actors, private actors as well. For instance, a project called Open Cloud Compute by People Plus AI that tries to make interventions in terms of interoperability in the cloud market. And just given that that is the background, I just want to say a few things about what G20 priorities ought to be, or what, a few issues that countries can focus on in the G20. First, I'm very, very suspicious of certain compute governance proposals. So, for instance, hardware interventions to restrict what can be done with chips, what models you can train, how big those models can be, or even hardware interventions that allow for remote shutdown of chips. I think these sorts of interventions, there might be some justification for it, but in a situation where there are such strong choke points in the compute supply chain, and only a few countries can affect those choke points through hardware interventions, I think such interventions raise questions about AI sovereignty and incentivize countries to, break away even more and develop their own compute sort of industries. I think that data governance should be a big priority in terms of thinking beyond making data available for AI models and just thinking about getting more value for the public for that data. And also thinking in terms of data and antitrust, because the major firms that develop AI models today are the firms that hold the most data that is not publicly available. And there is an antitrust issue over there. And also, I think antitrust in general, so considering separations of cloud provision and model development, or separations of chip development and cloud provision and that sort of thing. Another thing I haven't seen been discussed much, but it has been discussed today, is just about product and service standards and liability. So Joshua, I think very correctly talked about how there is a side tracking due to foundation models, even in the business world, I think, because a lot of use cases where you could be using a better model that is more accurate, people use foundation models that tend to make errors. And I think they're, in a lot of cases, they're only able to do this because the use of such models does not attract adequate liability. And so there should be thinking about applying equal liability to the use of these models as there is for humans or for other software. And I think that would automatically reduce applications that, denigrate product and service standards in the end. Again, like Luca said, I'm very concerned about environmental costs, and just a sort of, I think what is missing even in research is a cost-benefit analysis of the total social costs of computation and the total social benefits of computation, including environmental costs and benefits. I think some concerns ought to be concerned, some countries ought to be concerned about brain drain, because, for instance, India, a lot of the people who develop the most leading frontier AI models come from India, but that benefit does not accrue to India necessarily. And it's not a problem. It's not like there ought to be restrictions on the movement of people, but it is something for these countries to think about. And some countries, I think, should be thinking about potential job losses, especially in the IT sector, which is especially important for India, and what their plan is to tackle these potential job losses now that the technology has been unleashed upon all of us. Digital trade is an issue that doesn't get talked about much outside the trade forum. So the 13 ministerial conference negotiations are about to begin in a couple of days. And I think that there are restrictive rules being proposed during these negotiations that would affect the abilities of many governments to regulate the AI as a sector, AI sector. And so I think that more people should be paying attention to these negotiations happening in Abu Dhabi soon. And I just want to echo that the military use of AI deserves more attention, and as well as the use of AI in law enforcement and the risks it causes for people, especially marginalized people. Yeah, that's all I had to say. Thank you.
Fantastic. Thank you very much, Zai, for this really excellent overview of the challenges and really need to think also in the details of the kind of visions that one may have or not. And actually, this is the first thing that I wanted to bring into the debate for our next half an hour of debate. Well, first reminding all our participants that they can, those who are who have been subscribed to be in the Zoom, they can share questions in the Q&A chat. Those who are using the Slido, they can use they can share their questions so that we can integrate them in the debate. Unfortunately, Stella Agna told me that she cannot join us, and it's a pity, not only because we would have had first-hand information on what are the plans of the Brazilian government to push at the G20, but also because she's a member of the AI body established by the UN, which also aims at creating and discussing some sort of which kind of governance mechanism options exist. And this is actually really the first point I want to bring into the discussion. Felipe and I, together with a colleague, we are drafting a chapter of the Oxford Handbook on AI governance, focusing especially on the Brazilian experience of implementation. Because that is really something that usually is forgotten into policy discussion. The fact that even if we think that creating a law and establishing even an authority is an enormous effort, that is only really just the beginning of the regulatory journey and the definition of a governance system. Then the implementation of the vision we might have or not is one of the most challenging parts, right? And we see a lot of different examples from the experience we have been exploring. The European Union very straightforwardly establishing an AI office and a system that will implement the AI Act, but is not in place yet. So we cannot even assess how the model functions, the European model functions, because it's not fully in place yet. On the other hand, China, with these two levels that I found stressed very well, a central one, more linked to content regulation and regulation of how the AI evolves, and the local ones more linked to experimenting and promoting innovation. Then this other approach, very well described by Joshua, and very evident in the executive order of delegating to existing regulators, but also acknowledging that each of them needs an AI officer, because not necessarily they have already skills and capacity in AI regulation, right? And then this African approach, setting principles with an explicit recommendation, a strategy demanding for homegrown technology, but still at the very principle base, without defining the details of how this will be regulated and how. And last but not least, India, which is already a huge powerhouse of artificial intelligence due to the enormous skills it has, enormous data sets, it has enormous interest for investment given the size of the market, but still with very embryonic policies, and just adopted Data Protection Act, which is not in place, fully in place yet, and the regulator has not been created yet. So my first question for the panelists is, how do you think all the nice policies that we have discussed and that may be used as examples by the G20 leaders, how can they be translated then into implementable orientations, and by whom? Which kind of organs already exist, or we should try to create in order to, when we have vision, to put the vision into practice? You can either raise your hand, or we can go in order, starting maybe from Tatiana.
Yeah, I can maybe start. No, it's a good question, and I share with you that on one hand, we, as also the presentations today showed, we have a number of initiatives in all fronts on different levels, at the regional level, at international level, at national level, at sub-regional. So I think indeed we need somehow, increasingly there is a pressure to have a more structured kind of approach, but we also can focus our efforts. For that reason, for example, I think indeed, as Joshua has mentioned, the work at G7 was very instrumental to bring different perspectives together. And it was very interesting because within the G7 negotiations have been very, also sometimes bringing really, you know, like when you are in your own jurisdiction, you think that certain things are self-evident, but when you have to negotiate on the wording, you come to a conclusion like, oh yes, we had a bit different understanding. That's also, as Shiva has in his presentation, what AI system itself, you know, it's a big question which was negotiated quite intensively at the OECD level, you know, and it was not a given, you know, to come to the conclusion. So yes, we need this international layer to come, but also more talking, I think, between different layers. That's why I really like that this G20 builds somehow on the experience of G7, you know, but we also, you want also to learn from other experiences. So I think this is this kind of policy learning, but we are not each presenting just our vision, but trying to find the common denominators, you know, and build on this. For that matter, indeed, yesterday the AI office entered into force in European Union. So AI office will, from EU perspective, will be exactly, at least for our perspective, is one of the coordinating roles, so which will represent also in international relations and coordination of EU interests, so 27 EU member states. Exactly the whole setup of AI office, among other things, was exactly to have this one or stronger voice, you know, at the EU international relations. So this would be important, but I think there's still a lot of work to be done. Another maybe important element for me, beyond the just kind of political discussions at different constellations like G20 or G7, is also, I think, mentioned in some presentations, international standardization. So we have national standardization activities like NIST in US or Sensenelec in EU, but we have also a lot of debates at international standardization organization, ITU, and I think that's another type of forum where we need to work together to work towards building with standards, also technical standards, because sometimes in the policy discussions we refer to standards as norms, but there are also technical standards which also need to be developed, also benchmarks, how to measure accuracy, capacity, robustness of AI models. You know, we also need to go into there, because also this brings to different languages. So I think we need policy language, we need also technical language, and we need to bring it together and speak together in a different context. And I think I'll stop here for now.
As I don't see hands raised, I'm passing directly the floor to the next one. But I see Cesar with the hands raised. So please, Cesar, go ahead.
Thank you, Prof. Kelly. I think the need for a global standard, a global approach, a global attitude towards artificial intelligence it's imminent, it's there. What is interesting are the different regional efforts and continental efforts that are happening. And I think the importance that what I've heard today is that, you know, we need to take a little piece from every one of those efforts. The Asian effort led by China, the South African effort, late as it is, or led by Mauritius. South Africa will be angry with me for saying this. They have been better than us. And countries like Kenya, countries like Nigeria, Cape Verde, you know, let us move forward in terms of policy. Let us move forward in terms of implementing African policy, aligning it with international best practice. For many years, I used to play with the word international law, and I discovered if you want to be safe, policymakers, governments, you must talk about international best practice. That's my thank you.
Before we pass the floor to the next speakers, I'm seeing that there are several questions here, so you can also choose to reply to the questions we have from our participants. I'm selecting the first three, and then we might have a second batch of 3 questions. So there is one from Trisha Bogosian that asks, how do you see the issues of ethics and privacy being incorporated into AI governance? Then there is another one from an anonymous speaker on what kind of national security concerns do you have with regard to AI governance? Another one on the social and economic impact of AI and which kind of governance can mitigate this. And final one on how which kind of thinking is evolving amongst BRICS members, BRICS grouping members on AI policies. Feel free to reply to the question you wish, and we may go to Aifang, next speaker. Then I will ask Felipe to go on with the question answer.
Hello, everyone. So for me, I think that I can reply to the questions related to the national security issues. Basically, from the experiences of China, I think that certainly the national security is a big concern for the regulators, that especially for China, which is an authoritarian state. So that's the reason for which there is a political regulator like the Cyberspace Administration of China, which is in charge of regulating the AI, including for its technological innovation and also for the security concerns, because the security is the prime concern, especially for the Chinese regulators. But I think the dark side, so the negative impact of putting so much responsibilities to a political regulator is that such types of regulators tends to over-regulate, so tends to securitize basically the technology. So I think that so this is not basically the best policy design by delegating the regulation of the national security risks to a political regulator. Well, in this case, possibly it can be better to divide the competencies between political regulators and economic regulators, so as to give the firms greater predictability in terms of the investment, their policy design, and also their strategic orientation in the future. So instead of putting so much responsibilities to a single regulator at the central level. But the good thing in China is that we have the local regulator who are truly entrepreneurial, innovative, and also very bold in their trying new policies. So if there are the combination between these two levels, I think it can be fine. But it's not a good idea to give too much competencies to one single regulator.
Thank you, Aifang. Before moving to Joshua, I would just like to get back to very quickly to things that were mentioned and bringing a Brazilian perspective. The first one would be regarding the AI body. We've been facing this discussion here in Brazil as to which model should we adopt, both a sectoral regulation or to have a central body. And there's also obviously a very important issue, which is a budget constraint. That is something that is being discussed. Of course, are we going to create a new body that involves having more budget. And that is a huge concern. And I'd like to stress that, and Luca is somebody who has been working actively with this, which is our data protection authority, our DPA, is still warming up. It's been taking a while to actively start enforcing our data protection legislation. There are many gaps yet to be filled. And of course, the limits that come from budget perspective is also playing a major role. And that is the main concern as to the new AI office. Will it face the same difficulties that we have been experiencing, that our DPA has been experiencing? That is something that I'd like us to think about, and maybe that the other participants could comment on how they are seeing this happening in their region, as how these budgetary implications have played or might play a role as to the definition of the creation or not of a body for the implementation of the AI legislation. So I think Sizwe has raised his hand.
Thank you, Felipe. I actually love your question. Very important question. I always say Europeans can spend 100 million on data protection, whereas we as Africans spend 50 million on data protection. The fact that cybersecurity is important, it's there. You know, we have to spend money on cybersecurity. The fact that we have to spend money on artificial intelligence, it is there. It's not a like-have, it's a reality. So I will reply saying, I think there is a necessity for a regulator that deals with artificial intelligence, not just from a legal perspective, from innovation, research, technical aspect of AI, and that multidisciplinary approach to AI. I think that's important. A cybersecurity structure, be it a council, be it a body that deals with data protection, that deals with artificial intelligence, and our DPAs, our lovely DPAs, they should also be able to bring guidelines on artificial intelligence and guide people, be it responsible parties, be it data subjects or controllers, as you would say, on the dangers of AI and the benefits of AI, and how one needs to play within the privacy space of AI, be it in telemarketing, be it in the space of profiling certain customers. At those three: AI, cybersecurity, data protection. That's my take.
And that's something very interesting, because here our DPA has explicitly said, and they have released a statement claiming for the AI competences. So they've said in the statement, if an AI body is created, that AI body should be us. And that is something for us to think about. Should the DPA's structure be adapted to incorporate AI, or should we come up with something new, an AI office built from scratch, and to face the AI questions? Joshua has raised his hands.
Yeah, just a couple of really brief reflections. I think, you know, Luca's initial question about implementation and enforcement really is critical. And it kind of, I think it gets to your question as well, Felipe, in terms of, you know, when you think about the design, you also want to think about what's going to be most effective in terms of actually generating enforcement and outcomes. And we, at some level, we don't know the answer to that, because that's sort of, you know, with everyone's been very focused on policy regulation, and we're only kind of edging into this question of how's it going to work, you know, your point about the budgetary implications and so forth. what's clear is that there's multiple approaches happening globally. I mean, if you look at where the UK has gone, and the UK is really important here. They're obviously not part of the EU, but there's about a third of AI investment in Europe is in the UK, right? And so they are quite a central player when you think about Europe and what's actually happening in AI. And they've taken a very specific decision not to pass legislation, right? Not to do binding kind of top-down parliamentary-driven regulation, but what they're initially starting with is guidance principles, which goes out to existing government agencies to guide essentially their implementation of what they already are doing. And so they're kind of leaning into existing regulatory authorities, giving them additional guidance and principles. They're going to see how it works. They're creating a regulatory sandbox to experiment. They might legislate the principles to actually make them binding on government agencies, but there's no, I think, vision at the moment in the UK, for instance, for going down the kind of the European approach of an AI sort of top-down approach, right? Canada has done something a little different again. They've essentially passed a bill, but it is empty. It essentially says, we're going to regulate AI. We're going to develop, we're essentially going to develop the regulation, over time, in response to needs and development. So it's essentially a sort of very broad kind of overarching framework, but it essentially delegates everything to the existing agencies to then go forth and sort of develop regulation principles on an as-needed basis, right? So they're also leaning into existing agencies, but they're keeping it very open. Japan's doing something very similar with guidance and principles. And so you see a lot of this essentially views emerging, which is this is a very fast-moving technology. There's this regulatory need to balance, innovation and address risk. But the approach sort of is that's happening in a lot of the world is, let's sort of iterate as the technology develops. And so I think the first part of that is that you definitely want to, I think, take advantage of existing regulatory authorities, existing agency capacities, and build up those capacities that already exist. So there's a sort of a training and a staffing issue that goes on there. Then I think the other question is, how much of this do you want to lean into kind of providing guidance principles and then relying on forms of auditing and self-regulation that would be done by the private sector with elements of sort of oversight, enforcement, and fines. And this is where the budgetary thing is very hard to answer, because if you do that effectively, it can pay for itself, right? If you do that correctly. And so whether that produces, the right results is, I think, an open question. But I think certainly, the US, I think, will go down that path more rather than less, because that's been the traditional way that the US has tended to regulate these broad sort of economy-wide types of technologies, where there's a lot of emphasis on, if you're going to publish, a set of AI principles around safety, then we're going to expect you to follow them. And, if you don't, there's agency oversight and fines that will follow. And so, there's trade-offs in all of these different approaches. But I think this flexibility and this sort of nimbleness around regulating and thinking about how do you keep up with the technology is really going to be central. And it's really new. This is unlike almost every other technology in that in order for any of this to be effective over time, it needs to be highly adaptive. And this is something that's been talked about in the regulatory space for many years with other technologies, but it's particularly, I think, acute with AI.
Thank you so much, Joshua. Before passing the floor to Zai, I'd just like to comment on something. Shouldn't the strategies be different, considering that we are speaking sometimes about countries that produce technology and countries that only import technology or mostly import technology? Shouldn't the strategies be different? A more product safety legislation instead of a more principle-based in order to promote markets. Maybe that's something for us to think about in this conversation. That's something that is definitely being under discussion here in Brazil, considering the aspects of a country that is not a great, well-known country on producing AI technology, and how this affects the buildup of this legislation. I'd like to pass the word to Zai.
Thank you, Felipe. Just my general thought on this is I'm a bit worried about governments falling into the trap of having revolving doors or, through multi-stakeholder consultations and so on, just the trap of regulatory capture. Because if governments just think that they do not have the technical capacity to regulate AI and therefore they need to involve businesses and private sector actors in order to be able to regulate AI effectively. I think that a much better strategy than having these revolving doors is to build capacity within existing regulators. So, for instance, in the UK, the Competition Markets Authority has an excellent data unit. I forget what it's called, but it has people with technical capabilities and knowledge who regulate for competition. So it's a sectoral or it's a functional regulator. And I think this is a better approach than having a separate, agency like they do called the AI Safety Institute, which is just because I think that AI is so horizontal that what you want to do is build the capacity of every sectoral regulator to be able to tackle it in legitimate ways. And I also think that practically regulation tends to flow through regulators who happen to have capacity at that given point. So I think the reason that the FTC does so much regulation related to AI in the US is not necessarily that that is the, main regulator or those are the main issues, but that it happens to have the political will and capacity to do so. So I think we should be cognizant of the way that these things actually play out as well. And maybe governments can just practically think about which regulator has the capacity and creatively use its powers to regulate AI.
Tatiana?
Okay. Thanks. No, actually, my comment very much builds on the JS just saying, and there I want to disagree a bit with Joshua, how he presented European Union, because we are not top-down. Actually, the whole enforcement structure of the product safety legislation based on already existing market surveillance authorities in the member states. So I just don't have time to explain it, but basically AI office will be additional horizontal layer on top of already layers of existing authorities in the member states. So the market surveillance authorities, like explained, the product safety legislation logic means that the product must be safe before it's put in the market, but then market surveillance authorities have an obligation to see that product remains to be safe. And this will be supervised by market surveillance authorities of existing market surveillance authorities of a member state. So we have to designate the authorities, but mostly it will be relying. So for example, just to give an example, medical device regulators, we already have authorities for medical devices. So the task would be just extended also to supervise medical devices with AI, AI-enabled medical devices. So we already very much built on the existing, and exactly I agree that just setting up safety institute will only look at the existential risks, doesn't really help individuals on the ground, in their daily activities. But and that's why I think that's not completely correct, say that EU is just top-down regulating. I mean, this risk-based approach is exactly to find this balance and not just leave fully to the industry with self-codes and self-declarations, etc., to fully find this balance. We really think that the public should come in, and that's why we have in EU, this famous pyramid of different risks. So for high risk, we think the regulator should say, it's which type of requirements need to be met. But even there, we don't regulate exhaustively. We don't write all the specifications. And that leads me to this other part, which I mentioned before, technical standards. We actually involve other players, including industry, etc., to help us to develop these technical standards. So the public kind of regulator says, this is what you need to achieve. The AI must be trustworthy. Trustworthy means requirements on data, on transparency, on technical documentation, accurate, and so on, but operationalization of this principle is done not exclusively by the public regulator, but also with the help of the standards, the technical communities get involved. Therefore, I wouldn't really use the same language and really say, oh, EU and US US is really different domains, and this is top down, and this is yes, there are differences, but I think the logic and this understanding with this flexibility and regulation is necessary is same, but we just maybe the foundation is a bit different, the way we operationalize this. And we in the European Union strongly believe that you need this foundational layer of clearly setting the frames of the game, so to say. Yes, what is expected by trustworthy AI, especially for high risk use cases. Thank you.
Can I jump in quickly? Because I actually, just to clear up any confusion, I largely agree with Tatiana. I think the confusion is that the key difference clearly is that the EU's done an omnibus horizontal binding regulation, which is different to what the UK, the US, Japan, Canada, and everyone else is doing. I think it's true. It's a combination of sort of a horizontal regulation leaning into vertical regulatory authorities. You're going to rely a lot on standards development in the next couple of years, which will be crucial. But those are core differences. So I think there are similarities. I think the differences can be overstated 100%. I think, you know, there's going to be standards development, which will be crucial in terms of how the actual regulation looks. But the fact that the EU's done what, you know, this is what I meant by top down, is like a actual horizontal omnibus broad-based binding regulation is very different to what everyone else has done.
Yeah, just before giving I-Fang the floor, just a very quick comment on this, because actually this really builds on my perhaps a little bit provocatory question on the implementation. The fact that what we are speaking about is frequently extraordinarily complicated issues. If we speak about AI transparency or safe management of data in AI datasets, AI explainability, we are speaking of, or the meters according to which we can assess whether a dataset is transparent or not and is discriminatory or not. We are speaking about extraordinarily complex issues, and they cannot be set in stone by the regulator or by the legislator at a specific point. They need to be assessed and updated according to technological evolution. This is why actually something that I think a point that is very important and that I really want to stress in what Tatiana said, that the role of standardization and standardization body, the AI Act itself considers standardization as key to assess compliance with the Act. And this is something we have been participating at the center in the national policy-making efforts over the past couple of years, and in a couple of hearings, I also stressed that the fact that the Brazilian proposal includes a light version of the AI Act without specifying which entity will implement these critical issues is very worrisome, because we might have a very flexible regulation, a very flexible law if the bills that are currently in Congress are passed, but then they're useless if you don't know how to implement them, right? So, and to implement them, we may choose to delegate the task to a regulator, but good luck with that, because you need a regulator with extraordinary technical competencies. Or we choose to delegate it to standardization body, but this again it becomes then not really a regulation, but a co-regulation at best, or a delegation of regulatory power to standardization body in the worst option. So it's again another element of complexity, which, as we say, the devil is the details, right? So, and those kind of details, I'm pretty sure that G20 will not find a solution for this. But I think it would be useful to at least start raising this complexity, this type of complexity, into the G20 discussion. I-Fang, please, the floor is yours.
Thank you very much, Luca. Yeah, I think that I wanted to say something about the last question raised by Felipe Meudon about the countries that import the technology and the countries that produce the technology. Well, for me, I think that the countries that import the technologies like the AI, they have two advantages which can basically save the cost for the regulation of the high tech. The first advantage is that since they are since they do not have the AI or do not have a very advanced position in the AI development, so they can basically see to import the to see how the AI big states regulate the AI. So such experiences can be used by the countries that import the technology, so that can save quite a lot of time. And also the second advantage, I think, that so they can basically say, so with the unfolding of the technology in different countries, they can see what are basically the risks that are produced when the technologies are used in the big power of AI. So these two advantages, I think, that can be kind of an asset for the countries importing AI to save time, to have a relatively short learning curve, so to go through. For me, I think that it's not necessary for every country to kind of to have tried every regulation method, like the China and the China. We basically learn quite a lot from the European Union, because the risk-based approach is truly inspiring for Chinese policymakers, actually. So I think that this can be a good method. Well, of course, we have our basic realities, like for the African countries, for South Africa, for India. So every country can combine their own priority for the AI regulation, but basically, I think we can learn a lot. We can learn from the regulation approach. So without starting from scratch, yeah.
Excellent. Thank you very much, Aifan. Thank you very much to all the panelists. We are now starting to run out of time. So I would like to start closing this very inspiring and really excellent, stimulating debate. Just reminding you that this is the first of our series of webinar dedicated to digital policies in the G20. We will discuss platform regulation, information integrity, cybersecurity, meaningful connectivity over the next 6 months, trying to provide good food for thought for G20 leaders. We will have also a brief report of the key issues we have been discussing over the past 2 hours, and we will share it online over the next week. So once again, thank you very much for the panelists, for their excellent presentations, the very stimulating discussion, they're triggered, and a lot of food for thought that they provided us. Thank you very much and have an excellent day.